Although the system may have advantages for the parties in relation to the efficiency of arranging settlement and transfer of funds, a party contemplating the use of the system should be aware of the following risks. 1. The electronic settlement may be delayed by system failures. The contract provides that if a settlement cannot occur by 4 p.m. Australian Eastern Standard Time on the settlement date because a relevant computer system is inoperative, a party will not be in default despite that time is of the essence of the contract and the settlement date is deemed to be the next business day. While that risk also exists in circumstances where a traditional paper-based settlement process is used, in the electronic environment, the extension of the settlement date will be automatic. Generally speaking, apart from where the Land Titles Office computer fails and titles cannot be searched, in a traditional settlement, any extension will still be a matter for negotiation between the parties. For example, a party is not automatically entitled to an extension of time because of the failure of its financier's computer system, and a party may impose conditions on an extension to protect itself from financial loss. 2. A party to a transaction may, after having previously agreed to use the system, elect to withdraw from it. The contract allows the party to elect not to proceed with the electronic settlement by giving written notice to the other party. That notice cannot be given later than 5 business days before the settlement date unless the transaction is excluded by the rules applying to the use of the system, a party's solicitor is unable to complete the transaction due to death, a loss of legal capacity or appointment of a receiver or administrator, or where the financial institution of a party is unable to settle using the system. If one of the exceptions applies, settlement date will be extended by a period of 5 business days. This means in practice that the parties will still need to prepare for a traditional paper-based settlement process to ensure that if one party withdraws from the electronic process, the other party is still able to satisfy its settlement obligations on time. Having to prepare both methods of settlement may erode the efficiencies and cost savings of the electronic process and may well add to the work involved in preparing for settlement. 3. One of the main advantages of electronic settlement is the transfer of funds to the recipient of the settlement proceeds within a very short time. This will include not only the seller and the seller's financial institution, but also authorities with whom money is paid to discharge an outgoing. Any arrangement that involves the transfer of funds to a nominated bank account carries with it the risk that an error may result in funds being credited to the wrong account. The speedy transfer of funds may make a wrongfully transferred funds more difficult to track or recover. And 4. A traditional settlement involves a physical exchange of documents and funds provided by bank checks and, generally speaking, at any time until the exchange has taken place, a party may refuse to settle. An electronic settlement will require the respective parties to commit themselves to settlement of the transaction at an agreed time for settlement when the electronic workspace for the transaction will lock. The settlement process is to commence at this time and, unlike a traditional settlement where settlement may be aborted until final exchange, the parties will not be able to abort the settlement after the workplace locks and the settlement process has commenced. In limited circumstances, this may mean you discover issues with the property and, while the contract has not settled, you may be unable to exercise any rights. If you have any questions about e-conveyancing or whether it may be used for your transaction, please contact us to discuss them.